What we're going to do, since we are videotaping this, is your spokesperson will have to come to the front of the room, use the mic to give just a quick synopsis of the scenario that you walk through. You don't have to read the whole thing, just kind of talk through it. And then tell us the questions and what your group's thoughts were on how to address that. I think we got almost 2 groups for every young person, so we've got a good 15 minutes to do this, so I feel like you could talk about what you thought. So let's go ahead and start. We did Jessie and Athena as one. So which group, there were 2 groups that had her, which group wants to go first? You guys and you guys. You want to come up first and then we'll have these guys do it?
So you want us to do both of them?
Yep.
Okay. All right, so we had...
The mic doesn't amplify your voice, it just picks up for the camera, so you just have to just be loud.
Oh, okay. So we had Jessie and Athena. Jessie is 16, or actually he's been in care since he was 5. Since 16, oh, I am totally not right. Jesse's been in care since 16 when his father became incarcerated. His mom relinquished her rights at 5. He's about to age out. He has a lot of strengths. He's a caring person. Recently became reconnected with his mom via Facebook. Mom has a boyfriend who he also connects with. And he's determined to move out of the foster home that he is very involved with, but determined to move out and live with mom and boyfriend, who both have extensive criminal histories. Jesse's team is very concerned about the appropriateness of this decision. I think the important thing in this one is that he's determined to do this, so telling him that he can't would not work. So we just came up with putting together a team for him to help him develop 2 plans. 1, to make it work so that he could try to live with mom and boyfriend, and then 2, a different plan if it didn't work. So, and that's involving everyone currently in his life, and then those that he wishes, to add to that team. It's pretty much what we came up with. Athena, she is super shy and has social phobia. She has been involved with the court system since, let's see, it doesn't really say, but when she was 15, her parents' rights were terminated. She never really did attend court hearings. She tried, but usually had to have someone else speak for her due to her severe social anxiety. She refuses to participate, or did refuse to participate in Bridge to Independence because of the court involvement, even though she qualifies because she works as a pet groomer, and she could really use the housing stipend. So the biggest thing for her is not to have a court feeling. So making sure that maybe doing things like moving it to a non-courthouse, maybe an environment she would be more comfortable in. If it's going to be the same judge that she used as a youth, maybe the judge not have a robe and just look more like a not judge. I think those would be the most important things, because she associates those feelings with the court setting. And then what could the coordinator do? We didn't really get very far with this, but I think that a lot of preparation in advance, telling her what's going to happen, what could happen, explaining that it's different from when she was a youth, and then maybe finding if they could a peer that is maybe like her and has been through the system and maybe already in the program, and if she would accept that peer support, maybe try that.
Let's have our other group come up and share what they did. After this group goes. Yeah, that works. We're on the same page.
We had the same 2 groups, so I won't go over the story of them again.
Most of them.
For Jesse, we basically said that he needs an exit strategy. Let him go, let him have the chance to make the mistake, but then help him have a plan for after it falls through, if it falls through. We also said to keep the connection to the foster family and use them as an informal support as he's going through this transition. And go through him with a budget so that he understands that there should be a limit of how much money, if any, he would give to his mother and her boyfriend so that he can still support himself going forward. And also using the younger brother as encouragement and saying, hey, you know what, you really need to get to a good place in your life because your little brother's going to need you when he ages out too. And reviewing with him the criminal history and informing him that there's nobody to protect him anymore. So if there's drugs in the house and the police come in, he's charged as well, even though he didn't do anything wrong. As far as Athena goes, we said a lot of the same things the other group did. And we also said for the worker to kind of pinpoint why is she so fearful of the juvenile court. Maybe there's something that she can work through, hopefully with a therapist or something of that sort, in order to be able to work through that fear so that she can present herself in a courtroom, but also changing what the courtroom looks like. So sitting around a conference table, or maybe a Saturday morning, or a judge that has a therapy dog was brought up as well. You know, using any of those sort of informal things to help show her that it's different now.
Great, thank you. A couple other things to think about when we look at Jesse. Oh, let's clap for this group too. Sorry. A couple other things to think about when we look at these two cases. First, when we're talking about Athena, a big thing to remember is that young people do not have to attend their court hearing. So she doesn't have to go to court for her participation in B2I to continue. She can send her ideas and thoughts with another person, such as her attorney or her CASA or her independence coordinator. She could also utilize the court questionnaire and submit her answers in writing. And something else to think about when we look at Athena is that group home staff person is doing something that's working really well with Athena. So either that group home staff person could remain involved somehow on her team, or might have some tips, tricks, ideas for the independence coordinator on some ways to really build that relationship and that bond and support Athena. You guys did a great job hitting all the high points with Jesse. I don't know that I have anything to add. This is exactly the kinds of things that scenario was intended to have you discuss. Good work. Let's talk about Stacy. There were two groups, I believe, that had her. Am I right? Where are you at? You guys here? And then I think there was another group in the back, or no? Nope, she was our one that only had one group. There you go.
Great. Stacy entered care at 12. She has a strip of younger sisters, and they've all been terminated from parental rights. The three sisters went to the maternal aunt and were adopted. Stacy didn't have a relationship with that aunt, so she went to foster care, where she was happy and has a good relationship. She's done really well in school. She's looking at going to college. She's involved in sports. She's got a foster grandmother that she's also close to and does some volunteer work at the local animal shelter, and she wants to go into veterinarian school. And she's got a really good relationship with her current case manager. So the first question was, she plans to live with foster parents until she moves into the dorms this fall. She turns 19 this month. So she doesn't have any money management skills, what to do about this. And we suggested that right now the stipend, if it was in effect, would go to the foster family. But maybe she could be brought into the foster family at the kitchen table and they could help budget that money. So she gets a feel for how that works. Then again, she's also going to get some money when she goes to college. That should be kind of set out pretty soon. You know, they could almost enter into a learning situation where you're budgeting each month for that kind of money. So she should be able to do that with her new caseworker, and her whole team could help with that. But they could also offer her some, you know, there's some specific budgeting classes. So I think something like that could happen this summer. She hasn't had contact with her biological family since she was 15, except with a few words with her maternal aunt when she sees her siblings at birthday parties and such. How could this be taken into account? Well, somebody can ask Stacy if she would like the aunt to be part of her team or her sisters, knowing that, explaining that, as an adult, she's going to have to look at this. How is the best way to approach her aunt to have her sisters be part of her team? That would be a learning experience. That would be a situation where Stacy's going to have to work that out and figure out if that's the way to get to the aunt and communicate. She's also really worried about losing her current case manager when she ages out. So this is the case manager's job, I think, is really got to make sure that that transition team is looked at, and she's introducing her to the new people and telling her, how these, and then explaining to the new people how she's talked to Stacy. Why is this relationship so good? And the final issue was Stacy went to prom and had some beer. And she had the wherewithal, and this is from the prosecutor, to call the foster family for a ride home rather than riding home with other drunk kids. The aunt heard about this and now thinks that she's a bad influence on her 10-year-old brother, 12-year-old sister, and her 17-year-old sister. How might this be dealt with? Well, I think the independent coordinator and Stacy need to sit down and say, how do we communicate with Aunt about this? How do we explain those choices, bad and good, because they were both in that situation, in that scenario, and how can we take into account that this would be good or bad on the younger siblings, and how do we hold off her not getting in trouble with the aunt so that she can't see her siblings? I think it's really, really important.
Beautiful. Great job. The only thing that you guys are making my job really, really easy this time around. The only thing that I have to add was something that Doug and Megan brought up a couple of trainings ago when they attended, and that's that part of that notification process that the department will do as a young person approaches 19 about bridged independence will be done by the independence coordinator that may be taking their case. So she would likely have contact with that IC prior to aging out to really facilitate that warm transition from her caseworker that's doing such a great job to the independence coordinator that she'll be working with the next 2 years. So it's a wonderful process that the department has put in place to really kind of facilitate the shift of that. Good stuff. And I appreciate, and I'm glad that you guys talked about the mediator role that IC would play in that case. That idea of mediation and kind of convener is a role that IC is going to really have to play a lot in the transition process as they help the young person understand how to have relationships, how to respond in relationships, and then also to keep the team really thinking about how they're responding and reacting with the young person. Great work. All right, let's talk about Maria. Who would like to talk about Maria first? There you go. You're welcome. Loud and proud. So we can all hear you.
So Maria entered care at 13, moved through some foster homes, group homes, and residential facilities, and aged out of independent living and immediately took advantage of the Bridge to Independence program. She's doing well at college, lives in a dorm, and is working at a hair salon as a receptionist. At her monthly meeting with her independence coordinator, she admits that she's 6 months pregnant and is due early the next academic semester. She's decided to take the spring semester off while she has her baby, and it means she'll have to live off campus when the semester ends next week. So the first issue was addressing the shift in her housing situation. We talked about she could maybe go back to her former foster family and see if they would allow her to reside with them, if they have some ideas of where she could reside, if she could qualify for any sort of independent living programs or supervised independent living within the community, or if she could apply for Section 8 and see if she's eligible for those funds. Then with regard to the next question, while talking about her approaching parenthood with her independence coordinator, she talked about the last foster home she was in and the therapist that she saw while she was in care, and described how they were helpful and that they'd know how to make her a good mom. And how would this be helpful in addressing Maria's fear of being a good parent and lack of support system? We talked about how she could use her former foster family as maybe a mentor or support system through her pregnancy and then through becoming a new parent. Also seeing if there are funds available for a therapist through the Bridge to Independence program, or whether Medicaid would help pay for her therapy. And whether or not they could help her coordinate housing as well, and help her set up some support systems in daycare and things like that to help support her in being a new mom. And then finally, our last question addressed after having her baby, the salon that she works at closes. She doesn't have income, and she's not attending school currently. She's submitting applications to find a job. The baby's father can only watch the baby a few hours a day, and she has a very limited support system. She's trying to babysit for neighborhood children and earn a little bit of money for utilities and basic needs, but that's not 80 hours a month. And she also has 4 months before the next semester begins for her to be enrolled in school. She's afraid she can't find a job and become eligible for the Bridge to Independence program, which would result in her being unable to pay her rent. And how could we address those concerns? We talked about if she couldn't find enough hours in order to qualify for the 80 hours a month, that perhaps she could become enrolled in like vocational rehab or something that would at least bridge the gap for the next 4 months to show that she's trying to obtain employment, although she's unsuccessful. Whether or not obtaining unemployment would be something that would keep her eligible if she could get unemployment through her previous job. Whether or not being pregnant was considered a medical condition and would absolve her from having to meet some of the other requirements in the Bridge to Independent program. And the fact that she's enrolled in school for the fall, if that's enough, as opposed to actually be actively attending school since she's intending to go in the fall. And also that she could probably qualify for Title 20 funds for child care for her child.
Perfect. Do we have a second group that did, Maria? I thought so. Okay. You want to come up and then we can talk more generally about some of the awesome things that this group brought up.
We had a lot of the same similar answers for the first one, kind of talking about her shift in housing. Definitely kind of sit down and talk to her, discuss, there is going to be a shift, there is going to be a change, but you want to make sure that it's a safe and supportive change. Possibly because of her medical situation, if she's not able to work or go to school, she would still be eligible for those Bridge to Independence funds. Because if she is unable to do any of those because of a medical condition. She could look for affordable housing and explore options with friends and family. Again, that could be, with a previous foster family, maybe there are some supportive friends that she has that she could be roommates with, or other family. And then again, utilize the availability of community resources there in the community for housing. There might be some programs or independent living programs that could help out with that. The next question talked about, while talking about her approaching parenthood with her independence coordinator, she talked about her last foster home and her therapist. What we kind of discussed was, the possibility of reconnecting to a therapist, either with Medicaid funds or through Bridge to Independence funds. You really want to establish a support system for Maria. There's a lot of parenting classes and other programs in the community that you could utilize to help her do good with that. And she could also utilize a family finding program to maybe see if there are those other family members that are out there, or if the former foster family might have moved or something like that. She could utilize a family finding program to find those folks. And the final question kind of talks about how Maria is afraid she won't be able to find a job and will become ineligible because the salon closed for Bridge to Independence, which would result in her being unable to pay rent. How might you help Maria address these concerns and resolve her situation? Well, first you just want to discuss with her the option of participating in a program or activity to remove barriers to employment. Does qualify her for Bridge to Independence. So whether that's one of the many independent living programs that are out there, or doing like Goodwill's Heartland Workforce Solutions program, Nebraska Vocational Rehab, all that kind of stuff. And again, the medical piece could play into that too, depending on where she's at in her pregnancy when that happens. So that's what we had.
Beautiful. Great. Awesome. You guys again are covering a lot of the key things. We had a wonderful discussion in Holdridge last week with Doug and Megan from the department around looking at maternity leave and having that baby as a medical condition and whether that qualifies under that requirement within. And the program's not about seeing how quickly we could get young people out or kick them out easily, but the point is to look at those areas, talk with the department about how we might be able to be flexible in keeping them engaged, because she's on track to go back to school. She's doing everything that she's supposed to be doing. Could we count her babysitting hours and then maybe add some volunteer time and the time that she's putting in applications and have that meet the work requirement? She's doing all of the right things. So really understanding that, have that conversation and look at some other ways to fit her into that criteria. The other thing is to really look at those permanent connections and understand that permanency is also a piece of the Bridge to Independence program and ensuring that we're finding those connections, rebuilding those connections for that long-term work. Wonderful. Good stuff. All right, let's talk about Dante. Dante's my favorite out of all these young people. Just because I know we're gonna run into him. He's gonna come into the program and he's gonna challenge. He's really gonna challenge people. Who had Dante? Yes. I knew I gave him to you guys. I thought so. I like to challenge people every now and then.
Dante entered care at 17. He was truant and has had a few stints with probation, but those things happened after his mother abandoned him. The mother cannot be found. Dante has some serious trust issues, saying I either click or I don't. If I don't, then there's no point in even showing up to see me. He does keep in close contact with his former probation officer, whom he credits with him being able to successfully complete probation. Dante isn't clicking with his independence coordinator, regardless of what that independence coordinator does. And so Dante's requested a court review because he feels like he can't get the support he needs from his current worker. The first question is, how might you handle Dante's complaint? And what our group focused on was the fact that while in theory it's a great thing to say, well, let's see if we can't work with that, or let's see if we can't get Dante a new independence coordinator, the fact is there's a terrible shortage of independence coordinators, even in the best case scenario. So either by numbers in the larger counties or by distance in the smaller counties, that may not be a viable possibility. So one of the things that we talked about was connecting with Dante's probation officer, because he has a good and positive relationship with that probation officer, and perhaps the probation officer could use his influence to help him work, to help Dante work better with the independence coordinator. Also, we considered the possibility that the former probation officer, because he's no longer his probation officer, could qualify to help him through this. Maybe he could become or she could become a CASA volunteer, or perhaps qualify as an independence coordinator. We also talked about the fact that we need to talk with Dante about the fact that in the real world, you could liken this to, I don't like my boss, either I click or I don't, and so if I don't, you may as well not show up. Well, we're not helping Dante in that situation by helping him to not try with this coordinator. The scenario suggests or infers that the coordinator is trying and maybe Dante isn't. And also in the paperwork for the motion to request a review, we thought it might be a good idea to, he has to fill out the form. He has to get the form to the judge, because you do have a certain period of time where you can, let him maybe fail at that a little bit and then maybe pick him up on the other end. The group also suggested having a talk with the coordinator and perhaps having the probation officer also speak with the independence coordinator to see if there's perhaps some way that the coordinator could find to work better with Dante. He recently also received an increase in hours at his job, but he did not realize that the increase was gradual and would only be about 1 shift a week. So in the meanwhile, to celebrate his bump in pay, he went out and got a tattoo. And he spent his rent money to get that tattoo. Now he's unable to pay the rent. He calls his independence coordinator in a panic. How might you respond? Well, if you're not getting along with him, you managed to call him when you got in trouble. So, that's something to consider when you're telling us that you just can't get along with him. You did know what to do. We would consider, the group said, teaching him as part of his transition plan money management skills, seeing if there are funds that we can use to pay the rent with the condition that he does need to pay them back, helping Dante to find part-time work to cover the costs of that tattoo. And it is a perfect opportunity for the independence coordinator to work with Dante. Then when he wants this new independence coordinator, it's like you worked with him to get yourself out of a jam, so maybe you could work with him some more. Did I miss anything? Okay. Pardon me? Yeah, we talked about accessing community resources. I talked about funds, finding the funds to pay the rent and make a stipulation that he have to pay that back.
Great.
So that's it.
Great. Good stuff. I love getting that probation officer connected. I do want to point out that the probation officer probably cannot be the independence coordinator, but could absolutely have the option to be on Dante's team. Yeah. Did we have a second group that did Dante?
We did, but they literally said everything we were discussing.
Great. Right? Yeah. They got it. No, good. And you guys did cover it. And I like Dante because I'll tell you what, you're going to run into that. How many of us have thought we had something coming and it doesn't pan out and now we find ourselves in a bind? It's pretty normative life experience and really key to help get out. And I loved how you highlighted it as an opportunity for the independence coordinator and Dante to kind of have to work together, and now it is a learning. So good work. All right, let's talk about Jeff. Which group would like to talk about Jeff first? Group in the back, I think you guys had him, didn't you? Somebody have Jeff? Yes, you guys had Jeff, right? Come on up. Make me doubt myself, think I forgot to assign a young person to somebody. There you are. Sorry, I'm all in your space.
All right, we had Jeff. He was 10 when he came into care. He's been in multiple foster homes until age 17. When he got into high school, he started skipping school, kind of going down the wrong path, started using, and ended up with an addiction problem. He did get to a treatment facility and was able to graduate from high school or get his high school diploma. He also overcame his addiction program or his addiction problem, and he moved into an independent living program, and that's where he was when he aged out. At the time that he aged out, he was told that he was eligible for the Bridge to Independence program, but he said, I got it all under control, I got a place that I'm living, I'm doing fine, and that lasted for about 6 months. At that time, he had a falling out with the friend he's living with, and he finds himself homeless. He's working random jobs. He does get into a workforce development program, so he's looking for employment, and he does find some stable employment. And it's about that time that he comes across his handout on the independent living program, and he calls and he gets into the Bridge to Independence. At that time, he's doing a great job of managing his housing stipend. He gets into a studio apartment. He's working at, he finishes his employment program, and he gets himself a job at a construction company. He's working and doing really well. And so he meets with his independence coordinator. So the first question is, what do you do at that? What do you do now? Well, it's because it's a youth-driven program. It's really kind of up to Jeff, asking him what kind of help do you need? Is there anything else you need? but the independence coordinators will also have training, and they'll know different resources, and so they'll be able to suggest some things to him, and especially as they develop their relationship, that independence coordinator can give him some new ideas of, well, what if we look at this? What if we try some other things that might help you out? But really at this point, Jeff's doing really well, so it is really driven by him as far as what they're going to do. So he has one of his old friends, starts working at the same construction job that he's working at, and this is a friend who's a user, and pretty soon Jeff kind of falls back into those old habits. He starts missing work, and he gets terminated from his job for missing too many days at work. So what do we do now? Well, we've got two issues that we need to deal with now. The first is he's clearly going to become ineligible because he's no longer working. And the second is we now have a kid who's back with an addiction problem. So the first thing that they're really going to have to work on is what can we do to make sure that he either doesn't lose his eligibility or that he gets re-eligible within the time frame, which is essentially the 60 days. The 30 days when they have to give the notice, and then the additional 30 days he has to get himself back eligible. During that time, they can be looking at helping him find another job, looking at maybe getting back into the workforce development program or another job training program, look at whether there might be some community college or some programs, some educational programs that he could get into that would help him. We also talked about the addiction problem and what they could do as far as helping him get into a program. We talked about the possibility that if the addiction problem is really severe and he might need to go into an inpatient program, perhaps that could qualify as a medical condition that makes him unable to work, which would allow him to extend his eligibility. And then the final one, he finds out that he turns 20, finds out that his girlfriend's pregnant. He's pretty excited about that, always wanted to be a father. He reaches out to his independence coordinator and wants to get back into the program. So at this time, if he has been deemed ineligible for the program, his docket has probably been terminated. So he would have to reapply and show that he's eligible again. But that would be something that the independence coordinator would be able to help him to do.
Great. Do we have another group that did, Jeff? No? Okay. Couldn't remember for sure with him. Good. A couple of key things. First, I'm not sure about the addiction qualifying as a medical condition. Do you guys have any thoughts or feedback for that? Oh, there you go. Well, I didn't know that. So yes, that could work, which is great. And we hadn't had that idea come up yet. So I'm glad to see that.
No one could hear what she said.
Oh, I'm sorry. The woman that shared is a lawyer with the department. So. One of the things that your group shared was him potentially remaining eligible because his addiction could be counted as a medical condition that was preventing him from work if he was in an inpatient intensive treatment program.
Yeah, we don't want to give the impression that having an addiction will always excuse a young adult from the employment or education components. But if it was a situation where a doctor signed off and said, yes, his condition is bad enough that he is unable to work or do these other activities, then we would accept that as documentation of the medical condition. But yeah, a substance abuse facility does qualify as a living arrangement under the program, so there's no reason that they can't live there and stay in the program.
Great. Did everybody hear that? Yes? Okay, good, great, thank you. Glad to have you guys here once again. Great. Another thing that Jesse's case, along with a lot of the others, point out is there's going to be times as these young people are in care or in the program where they're going to be in a bumpier spot than normal. And while the program requires that once monthly face-to-face contact, it's essential, especially during those times, that that contact be more regular. That doesn't have to be face-to-face. It could be a text, an email, a phone call to just check in. Key example is Jesse's case. You know that Jesse just graduated. He's moving in with his mom and her boyfriend this week. And so you know that experience is going to start to happen. Some of the things you're afraid are going to happen might start to play out in his life. So it might not be a bad idea to shoot him a text and say, hey, I know you moved today. How'd it go? Or, hey, haven't talked to you in a couple weeks. What's going on? Check in. Not necessarily say, so how's living with your mom? We give him the opportunity to know and be reminded that he has that support in you and that you guys could talk about that plan B if something was going out. oftentimes that simple reach to say, hey, I'm here if you need something, opens the door and reminds them that they can come to you. Great. Yes, sir. Let me get you the mic. I'm going to get talked to. Yeah, they need it for the recording, though.
Okay. What I was curious about
Yes.
was the answer that under the program rules that addiction counts as a medical condition or not?
No. The answer was they don't want to give the impression that having an addiction always disqualify or make sure that the job or school requirement doesn't count. If a doctor writes a note that their addiction is serious enough that they could not work, they could not go to school, so they're in an inpatient facility, then they would accept that doctor's note as documentation. Did I say that correctly? Yes? Okay. Does that make sense? So it depends is the answer.
So there's nothing clearly defined in the rules then?
No. Nope, it would fall underneath that medical condition that prevents them from working area.
You're talking about the barrier then? The barrier condition or
Yeah,
the diagnostic?
the barrier and the conditions to eligibility for the program. Mm-hmm. Yeah, yeah. New program, things have to be worked out still. Great. Are there other questions? This is an opportunity to ask those types of content questions, application-based things. Yes, let me walk this back to you.
Not directly related to the scenarios, but is there a plan for what to do with the GAP kids, the kids that are not getting former state wards now and the program isn't up, so that they know about it after they've left the system?
Yes. Yeah, Sarah talked a little bit about that a little while ago. There's been some private dollars that have been secured to kind of cover those GAP kids, and so
I'm talking about so they get noticed once they get done.
the
Once
department.
the program is up, how are kids going to know that are already aged out that the program's up?
Oh, to be able to be involved in Bridges?
Right.
They're already working with, and Doug, correct me if I'm wrong, but if they're receiving the GAP funding, they're working with PALS, correct?
Either PALS or one of the other
Or one of the other providers?
programs, or
Mhm.
NOC, yeah.
But if they're not receiving the GAP funds, 'cause
And then they want to be,
kids are aging out now
Mhm.
because school's getting out. So those kids are not necessarily connected yet with the PALS funds, the old PALS funds. But they're gonna, the program is also.
so her question is for those young people who age out during this GAP period, did not choose to be involved in the GAP funding, how will they be made aware that Bridge is now up and running and that they could come back in, correct?
Yeah, and I don't think that affects, there's, I think, 2 or 3 young people since January 1 who are not, sorry. There's,
Doug.
I think, 3 young people who've turned 19 since January 1 who are not in receiving GAP funding, and that's because 2 of them are out of state and 1's incarcerated. So if you're working with a young person and they've aged out since January 1 and they're not receiving GAP funding, that means they're not eligible for Bridge, probably because they were maybe an OJS case.
So there shouldn't be a lot of those kids. However, you do bring up an issue about the young people that might have aged out prior that are still in that 19 to 21 range that would qualify. And that's just going to, there's no big public marketing campaign that's going to go out. That will just have to be as a word of mouth and sharing and informing them as we work with them to let them know that this is available.
Stay up here, Cassie.
Oh, yes, that's right.
So we're going to just spend maybe 10 or 15 minutes going over the team planning guide. If you could pull that out, that's the yellow sheet.
Yes.
We've done this different ways depending on the location, and what we found works best, and we're going to try here, is to just do this in one big group. And that's because a lot of these questions kind of lend themselves to the judge, having a judge here, and unfortunately I know we don't have any judges today. So we're going to kind of lead a discussion, but we hope that you all will kind of jump in. Since we're using both the mics, maybe what I'll do is I'll repeat the comment. Will that work? So, but hopefully, so feel free to jump in, and we'll go through some of these for about maybe 15 minutes, and then we'll finish up with the maybe a little bit early, even after I give a little bit the final piece on the Affordable Care Act.
Great.
Okay. So the first question on the yellow sheet is, how will the B2I permanency hearings be structured? How will the court set hearings and distribute reports? And how will young adults access information? For example, reports, notices, etc. So I don't know if we have any court professionals here that want to jump in or give any input into this. But anyone? Yes, please.
I know in Sarpy, in Sarpy, we're planning on the hearings being very non-court oriented. And in fact, probably not even at the courthouse, but at perhaps some place that involves pizza. So beyond that, I can't tell you about any other plans, but I do know that we are planning them to not look like court.
Great.
Anyone else? Okay. Linda, would you like to know anything? Okay, yeah. I'll actually take this too because you're close enough.
Actually, I just had a question on how these would be recorded if they're going to be off-site.
So the question was, how would oh, you had the mic, great. How would they be recorded if? Yep.
Yeah, our court reporter went to all our drug court meetings that were held at the pizza place, so I assume our court reporter will be here too.
Great.
Great. And another option that has been discussed that I think in Lincoln, Omaha might be a possibility where it might not be in the smaller counties is pizza is a great location. I know that's been used before, but another great place, maybe Project Everlast. They have a location in Omaha and also in Lincoln, and that's a place where a lot of the young people are already comfortable. If you've been there, there's a conference room and couches, and that's a place that can help young people also get connected with that support system. So that's, I know, something that Project Everlast and others have talked about as an option. So that's great.
Absolutely.
Okay, the second questions are, how can young adults request an additional permanency hearing, and how can young adults request an attorney and or a CASA volunteer? That was partly a question to see if you were paying attention, because one option is the model, the sample motions for young adults. But, as I said, that other judges have mentioned, as we've traveled across the state, young people can just write a note also. And so we want to get that word out to young people too, that they don't have to do anything fancy to request an additional hearing. The next question is, how will information from case reviews be utilized in the permanency hearings, and how will information from the case review be utilized in the young adults plan? I want to open that up. I'll preface it by just saying we've had couple of conversations with the Foster Care Review Office. I know they're really busy getting their process in place for those 6-month reviews, and do plan to provide their report to the court and also the other parties, and their recommendations and findings as part of that. Is there anyone here that has any questions or thoughts on that process? I know there's been a lot of discussion also among stakeholders about wanting to really use that 6-month review as an opportunity. It is intended to be a time where young people can raise issues, and that there can be sort of an external check to make sure that the plan is progressing and meeting the goals. And so that is a time where some of those issues might be flagged to be amending the plan, or to raise issues and just to make sure cases are on track. So that's really the intent of that tool.
Yeah, it's really thinking about those meetings as more of a board of directors meeting for that young person and less of a court review process.
Great. And then the next one is, what is the role of and what actions should be taken by the independence coordinator when a young adult brings forth grievances about the program? And what about grievances with the independence coordinator? I'm going to throw this out if anyone has thoughts on that.
And this group talked a lot about it when they did talk about Dante's case. And it is a really thin line between enabling and empowering. When you talk about is the right choice getting them a new independence coordinator, which the department has indicated in previous trainings is an option in some cases, if that is what's best for the young person, or is it more beneficial to them to help them work through that relationship as a learning experience. that there's probably no clear answer. It's going to be another depends, as is the answer with a lot of questions regarding this population. But you guys had, I think, a great discussion around that question. Yes?
Is there a process in place for that?
For grievances? In the regs, there's a process, an administrative review, right?
Yes. Yeah, would you like to speak to that? Yes, I'll bring it back. I feel like Oprah in the old days.
Yes, there is a process for that. We will, when we first begin working with the young adults, talk to them about, what they can appeal, the decisions that can be appealed, let them know how they can go about doing that. They'll have a form that they can use to do that. They can also just write a note and submit it for a department administrative review of that. So we'll let them know about that process. On that topic, I would also say that as a supervisor for the program, I would really love to know if the young adult's having any issues with their independence coordinator. So I would hope that we can make it clear to them to give me a call, enlist anybody else involved with the case, their attorney, their CASA, to give me a call. Let me know there's some problems. I'd be happy to talk through it, go out there and meet with the young adult, see if we can brainstorm some ways to improve the relationship, fix the relationship before it gets anywhere near needing a formal administrative review or a formal grievance. But we will let them know that option is available to them.
Great.
Okay, and the next question, I left you without the sheet, or maybe.
Oh, no, I haven't. I'm sorry. I was just
waiting
getting
for
ready
me.
to defend
Is in addition to the department's responsibilities and statute and the specific requirements of transition planning, how can other system professionals help young people know and make a decision about participating in the program? And then, in addition to HHS, what role can and should other professionals play in informing foster parents, guardians, and adoptive parents about this program? We've talked a lot about how we can let young people know, but I think that's that last question gets to an important piece of it too, is how can we, be talking to foster parents about, whether that would be a possibility from their perspective to have the young person continue to reside in their home, and that these payments are available also to guardians and adoptive parents to age 21. So I'll throw that out in case there's any questions or comments about that process.
The question really alludes to the idea that and the department is doing training with workers on this right now as well, that transition process and the options that come post-19 really do need to be discussed in the team for that young person, and that team approach really needs to start being implemented prior to them taking part in Bridge to Independence, so that this conversation would be had with their CASA and their foster parents and all those people at the table already, those people that are already invested in that young person succeeding post-19. To continue that process.
Yeah, exactly. So CASAs, I know PAL's talking to young people and just making sure that they understand. Yes?
Yeah. Getting back to the question of the young person asking for a CASA or asking for an attorney or whatever, is there somewhere in the process before it gets to that point where the young person has had the roles defined as to what a GAL is there for or what a CASA is there for? I mean, whose responsibility was that?
The department is required to provide notice to the young person, people about, as part of their notice at age 16, nearly thereafter, and then 90 days before the last court hearing, and that includes notice of their right to an attorney. And I can't remember if it specifically says in statute about the role there too, but I assume that will be included and explained by the independence coordinator to the young person.
I've had adults that did not understand the role of a guardian ad litem, and it really is an issue. So, if you're asking a youngster to ask for something, they need to know what the role is. So I was just wondering how that,
Yeah, so he's just saying, I'll repeat for the recording, that there's adults that don't understand what the role of a GAL is, and again, this is a client-directed attorney, but how does that shift? And so I think that's right. That will be important for the independence coordinator, and also that's something that the GAL could do, the under 19 GAL could do. They would be in a good position to explain that as part of the transition planning process, even if they are not going to be the one to continue, but explain that that's an option and what that looks like.
We've also worked really closely with the department in the development of the materials that will be used to inform the young people about Bridge to Independence. And all of those materials are seen, will go before the eyes. So their brochure about the program, that type of thing, will go before the eyes of our council members prior to being used. So they'll be able to say, this, as a young person, I would pick this up and be able to understand and read it. It's friendly to me, I get it, provides all the information, or it's missing these things. So the department has been really utilizing young people to ensure that how they're educating them about the program would work.
When a child is 16 and they're on a 3A docket, is this something too that the judges are going to be talking about regularly at the review hearings and things? Because at least with the former wards funds, sometimes those weren't ever discussed, and then it was just sort of left to the child or guardian ad litem or someone to sort of try to figure all that out. And it seemed that it was not exactly clear as to how things were going to be accessed, and getting the child on board with understanding all the opportunities that were available.
The hope is that the judge will bring that up as part, in addition to the department talking with the young person about it. But I don't know that it's formally mandated that they do that.
It's not specific. I don't think it's explicit in statute, but I think that's a best practice, and would, I think a part of the transition planning to have the court check in on that. So that's a good point.
Each young person, the department has done a lot of work around that transition planning, and each young person will be leaving the system with a Know Your Rights booklet, or that will have all of their key information in it, and there is information about Bridge to Independence in that booklet that should be gone over with them as part of it. So hopefully that will help to avoid young people getting out and not knowing that it was an option. That was also part of the rationale for young people when they said you have to be able to come in after 19 with some of the previous opportunities for them. If they aged out and they didn't know about it, when they aged out, then they just couldn't access it. They were done. This way, if they don't find out about it, maybe until they talk to a peer at 19 and a half that they could have done this, they can come back and access it. So it's not an absolute, oh, you're too late.
But they should have heard about it.
Yeah, they should have. That shouldn't happen, but in case it was written in that way specifically.
With the family finding, there's a huge push for us to put kids with family even if they're out of state. So is this program going to make those children ineligible just because we're putting them with family if we put them out of state after they're 16?
That's a great question. I don't have the answer to that question. As Sarah walks towards the department.
If there's still a foster care placement with a family, they would be eligible.
So you said yes, as long as they're still in foster care? Okay, great.
Great. Well, are there any other questions or comments on that? We talked a little bit about the informal hearings, and I challenge you to continue to have those conversations in your local teams. I understand the Omaha team maybe has a subcommittee, a Bridge to Independence subcommittee. That's very exciting. So we want to encourage you to take the yellow sheet and use that as your team planning moves forward. And we just hit on youth engagement. We would be remiss if we didn't mention one of the questions there is, how can your team continue the spirit of Bridge to Independence in key implementation decisions by including young people in planning for this program in your community? And I just, as I mentioned, young people were involved so intimately with the creation of this program, and so we really challenge you as well to include them with your local teams, and as you're implementing this locally, to get their input into the process and can connect with the council as well.
And in Omaha specifically, and in this area, there's a wonderful relationship between our Omaha-based council and the judges already, and they've already been working together, not necessarily on Bridge to Independence, but on other things around making the court process more friendly, and the judges are really eager to have that relationship and have had some significant face time with the young people, so there's some trust there already. So I think you guys are positioned better than anybody else in the state to build upon those relationships because the judges have already begun to build them. So I'm excited to see what comes out of this area around that work.
Great. One more question.
Yes.
I just wanted to see you walk back here in those fields.
No, going back to Dawn's, I think it was Dawn's question, you have a child who's placed with a family outside of Nebraska at 16. They turn 19. They're no longer under the jurisdiction of the court. They're no longer in a placement. Do you, and they want to stay in the state where they are with that family member in that same state, can they receive services in that state from bridge to independence? Or do they have to reside in Nebraska to receive services?
They don't have to reside in Nebraska. Okay.
So you get a team going up in North Dakota or something? I mean, I'm not being facetious.
Yeah, do you want to address the travel or the ICPC? Can you do mine?
Hello. Well, we're working on the ICPC process to see if we're going to develop teams in the states that have programs like the Bridge to Independence, or we'll just be having workers every month going out to see their young adults in the different states and seeing how they're doing and using informal supports to make sure they have all the services necessary. We don't want to exclude kids that move out of state with family, especially for the program requirements. Mm-hmm. Yep.
Yep. Again, we are so lucky and so excited that it just worked out, that we've had folks with the department, especially these two, to be here for all of these, because I don't know how many questions we've just referred to you guys. But I think it's indicative of how, from day one, this program has really been a partnership between us and the department, and that there really is openness to it doing what it's intended to do, and that's get best outcomes for young people. So thank you again to you guys for being here.
Yes, and it not just worked out. They made the time in their schedule and travel to be at them, so we really appreciate that.
Yes. Great.
Okay, great. Well, I'm going to just, thank you.
I'm going to. Are you good?
No, I'll just do this.
Great.
It's fine. So I'm just going to spend the last few minutes here, maybe about 10 minutes, talking, as I said, about a new provision of the Affordable Care Act. And I want to just start by making a distinction, because we've heard a little bit of confusion of folks thinking that this provision of the Affordable Care Act and Bridge to Independence are the same thing. The provision of the Affordable Care Act, otherwise some people call it Obamacare, I call it the ACA, is for youth formerly in foster care, and if they're eligible, they can receive Medicaid to age 26. Most of the young people in the Bridge to Independence program will be accessing Medicaid, and they'll technically will be under this provision, but it's not the same thing, because young people can be separately eligible for the Medicaid to age 26. And another important distinction is that the ACA is in provision. This provision is in effect now. So I want to walk through just some basics of the provision, but I'm going to start by giving just what I'm calling ACA 101, because I think it's a law that we hear a lot about, but sometimes get confused on the framework of it. So the Affordable Care Act created tax credits for individuals with incomes between 100% and 400% of the federal poverty level. And that essentially reduces the amount an eligible person pays every month for a health care plan if they access it through the new marketplace. And then the ACA also made 2 changes to the Medicaid program by adding 2 new coverage categories. And the first is that the law extended coverage to all adults between 19 and 64 with incomes under 133% of the federal poverty level. And this is the provision that the U.S. Supreme Court ruled is optional for states. That's otherwise known as the Medicaid expansion, and as you probably know, Nebraska has not yet taken that option. So for childless adults who do not fall into one of the other mandatory eligibility categories and whose income fall below 100% of the federal poverty level, there's a gap. There's 54,000 Nebraskans that fall into that gap. And then the second new coverage category that the ACA created is the new mandatory eligibility category for youth formerly in foster care. That's the one I'm going to be talking about, and the U.S. Supreme Court decision did not impact that new category, which remains a mandatory. And so it's mandatory for states. That means they have to to do it. It's not an optional category. And there are no income limits or assets tests for this category. The intent was to equalize insurance coverage among young adults and to put them on par with their same age peers who, under the Affordable Care Act, are able to stay on their parents' private insurance to age 26. Okay, so now I want to just walk through kind of the eligibility provisions. This is the language of the ACA and the Social Security Act. Young people are eligible if they're under 26 years of age. This prong is essentially not otherwise eligible for another category of Medicaid. And then this one in bold is the one that I'm going to walk through. I think it's the most important one, that they were in foster care under the responsibility of the state upon attaining the date on the date of attaining 18 years of age or such higher age as the state has elected. And then the final prong is essentially that they were on Medicaid while in such foster care. So there's the language again. And I want to walk through kind of each of the pieces of that. The first, in foster care, there is federal guidance for this program, and the federal guidance has defined in foster care under that federal regulation there. And it says foster care means 24-hour substitute care for children placed away from their parents or guardians and for whom the state or tribal agency has placement and care responsibility. This includes, but is not limited to, placements in foster family homes, foster homes of relatives, group homes, emergency shelters, residential facilities, child care institutions, and pre-adoptive homes. This does not include guardianships, and the federal guidance has explicitly said that does not include guardianships. So unfortunately, that creates a pretty significant disincentive to permanency, and I know we've heard of situations of judges dissolving guardianships in order to make young people eligible for this provision to age 26. At Appleseed, we're doing a little bit of research to see whether young adults may be able to stay on their guardian's private insurance. I know many guardians don't have private insurance, but if they may be able to fall under that provision, or if they have a guardian that's able to access coverage through the marketplace. But we haven't gotten far enough in depth to see if that might be an option. But that is a gap, and something that I can say I know national advocates are concerned about and working on as well. And then under the responsibility of the state, the federal guidance has also clarified that states may cover young people who age out in other states, but they don't have to, and Nebraska has decided not to. And so if young people age out in Iowa and move here, they are not eligible for this coverage. But something for you to know as you're working with young people who age out in Nebraska, that if they move to Iowa or Kansas or anywhere, they'll need to just find out whether that other state covers young people under this from other states to 26. Okay, and then on the date of attaining, we understand this to be a point in time test. And so we understand that young people must be in care on their birthday. And so that's another one that we really, a take-home message that we want to share, is because we hear about cases where, from young people and others, where cases are closed a few days, weeks, or months before the young person's birthday, and our understanding is that that could render young people ineligible for this Medicaid to age 26. I don't know if there will be flexibility at the federal level, but that's, I think, an important consideration that we wanted to get across to you all. And then the or such higher ages the state has elected. The Nebraska regulation, proposed regulation, is interpreting that young people need to be in care when they age out, and they're interpreting that as age 19. At Appleseed, we think that if they are in care at 18 or 19, that we read the federal language and understand it, the guidance to allow young people to be eligible if they were in care at 18 or 19. I did want to let you know that the department's interpretation is 19 at this time. I have asked CMS on a national advocates call. They affirmed our understanding, and I've shared that with the department. And I understand that there's just, that they're also trying to talk and figure that out. But at this time, the state's interpretation is 19. That's significant because the data shows that about 100 young people every year are discharged between 18 and 19. So if you're encountering young people in that situation, please let us know. There are links to the federal guidance. There's a proposed federal rule. There's not yet a yes. Yep.
So you were referring to that former foster care category, and you referred to individuals that age out between 18 and 19. And I know that in your materials and elsewhere, you're referring to kids that are that are closed out to independent living before age 19. So my understanding of the federal law and the federal guidance is that you have to have been in foster care in order to be eligible for the Medicaid foster care category. Are you taking some different interpretation that that you keep referring to independent living youth getting into that category?
No,
the question is, my understanding is that the federal law requires an individual to have been in foster care in order to get into the foster care category. So, to state it another way, isn't the age issue irrelevant in terms of individuals being discharged to independent living because they won't meet the foster care requirement?
I think they would have to be in foster care on their 18th. If they were in foster care on their 18th birthday, we think they would be eligible.
If between their 18th birthday and their 19th birthday, they go from foster care into independent living, your interpretation is that because they were in foster care on their 18th birthday,
Correct.
they later go into independent living, no longer in foster care. So on their 19th birthday, they're in independent living instead of foster care. You're saying they'd still be eligible.
Correct, and I can repeat that. So we're saying that if they were in foster care on their 18th birthday, our interpretation is that they would be eligible even if the day after their 18th birthday they went into independent living, and on their 19th birthday they were in independent living.
And the department is taking the position that they have to be in foster care on their 19th birthday. Is that your understanding, Sarah?
That's my understanding of what the federal law stated. So let me ask another scenario. So what if it's the same individual who is in foster care on their 18th birthday and then the next day are reunited with their parents? Is your position the same for that young adult?
I think that yes, if they were in foster care on their 18th birthday or their 19th birthday, they would be eligible, is my understanding. But as I said, we have it's an open question. So, open question. So, but something for folks to certainly be aware of. Okay, so what can judges, attorneys, and others do? Don't close cases before the applicable birthday unless there's a reason that overrides this healthcare access. And then make sure that HHS is including eligibility and enrollment for this provision as part of transition planning. So this is specific in our transition planning statute 43-13-1103. Says that potential eligibility for this provision is required to be a part of the transition plan, and so other system stakeholders can, kind of play a part in making sure that's happening. And then we also think that the department has a duty to provide ongoing eligibility determinations and to redetermine eligibility, so when someone becomes ineligible for one category of Medicaid, to automatically determine if they're maybe eligible for another provision. And so it's as we talked about, it's one thing to try to do outreach and reach out to young people who maybe 24, 25 and have already left the system, to let them know that they may be eligible for this provision. but we should be doing 100% for young people going forward as they're aging out of the system, and helping them get access to this coverage. So that's something that U.S. system stakeholders can play a role in. And then we also have resources on this as well. We have 2 fact sheets, and one is for attorneys, judges, and other professionals. And then we also have a fact sheet for youth that you can provide to young people. It's youth friendly, and there's a frequently asked questions on the back. And then we also, several of my colleagues wrote an article for the Nebraska Lawyer in January of this year, and it goes over a little bit more depth about the ACA and this provision in particular. And so that is reprinted with permission in your materials. Are there any other questions? Yes.
If the youngster is on Medicaid and in foster care, and if they're otherwise qualifying under ACA, is Medicaid picking up the premium for the ACA, for the coverage? Like, a little confused. Hmm? Okay, so they'll still, even if there's a gap, I mean, if they aged out, let's say, say they're out of the system, let's say they're off foster care, at age 18, and then they want to get in, will Medicaid be reestablished in order to cover them under ACA? Well, I mean, if they get into the, into the bridge program, okay, but there's a gap between the time you're talking about foster care being terminated, let's say at 18. Okay, but then they want to come in, will Medicaid pick them up to pay the ACA premium? Who's paying it, I guess is what I'm saying.
For a young person that's in the Bridge to Independence program?
All right.
Most young people in the Bridge to Independence program would be covered under this provision of the ACA.
Okay.
They'll be covered under Medicaid, but most of them will be covered because of 4D eligibility, not under the former foster care category.
Okay, so they'd be covered under Medicaid, but I guess we are, and I don't disagree, that we're discussing about the different particular categories of Medicaid, but for the young person, they'd be covered by Medicaid, yes. Great. Are there any other questions? Okay, well, thank you all for coming. If you have any questions as things move forward, feel free to reach out to Cassie or myself and our organizations. We're always happy to provide resources and answer questions. Thank you.